May it please the court, my name is Judgement.Covey of Covey Law Group for the defendant PepsiCo. I'm here today on a motion to set aside the default judgment of September 30th, 2009 for the $1.26 billion in order that the case might be resolved on the merits rather than by default. So according to Rule 60B1 of the Federal Rules of Civil Procedure, the court may set aside a final default judgment for mistake or for excusable neglect. The Fifth Circuit in the case Rogers v. Hartford Life and Accident Insurance Company, which is a 1999 case, says essentially that sufficient grounds exist for setting aside a default judgment. One, by assessing the culpability of the party seeking relief. Two, determining whether the party opposing relief will be prejudiced. And three, by considering whether the party seeking relief might have an otherwise meritorious claim or an otherwise meritorious defense. Now, my client is represented legally by their general counsel, Tom Timoni, and Mr. Timoni didn't know of the lawsuit filed against the defendant in mid-September until he saw the papers in early October. And this was over 3 weeks after the service. His administrative aide had received the papers, but she had set them aside, and in her haste to take care of business, they got mixed in with the shuffle of other papers on her desk. And my client's agent, also in North Carolina, was served, but the notice wasn't delivered to headquarters in New York until mid-September-ish. Your Honor, this is not not responding was not a strategic decision by my client to ignore the lawsuit or to somehow thwart judicial proceedings. It was a mistake, and it was a possible but understandable excusable neglectfulness where papers got lost in the shuffle of a huge company, and they had processes and procedures in place to prevent this kind of thing, and yet it still happened and it still got lost. And Mr. Timoni certainly would have responded with the promptness which the issue deserved if he had simply been informed of the existence of the papers. So we would ask that the culpability issue, that they weren't culpable. Further, the plaintiff will not be prejudiced by the setting aside of this judgment. They haven't spent the damage award, and there's no impending deadline or reliance that they've alleged that they would be detrimentally harmed, or their position would be detrimentally harmed by the case. Simply losing the damage award isn't traditionally considered to be a basis under 60B1 for finding of prejudice. So we would ask about the prejudice, which goes to the prejudice issue. And finally, since the initial complaint alleges facts which occurred 28 years ago in a PepsiCo office where the plaintiffs first made their pitch to my client regarding the business venture. Since that time, my client has developed new procedures and methods which don't copy or infringe on any of the patented ideas, and we believe that these new procedures and methods and our defenses would present a meritorious defense. And Your Honor, $1 billion is a very large amount. And essentially for what amounts to a paperwork mistake. And we would respectfully ask, Your Honor, that the court allow this matter to be resolved on the merits rather than default. And I do thank you for your time.